Good afternoon, everyone. Like Jeff said, my name is Chad. I serve on the board for this organization. And first, I want to say that it's kind of cool looking around this room to think about what our friends and colleagues say at the Orlando conference and how far they've come and how much that event has developed over just a few years, and to think about what our organization and group could do in the coming years. But even today, in what's only the second time that we're doing this, we have an exciting variety of guests to talk about some of our oldest traditions and principles in the context of modern challenges and even some new ideas. And this panel on common good constitutionalism explores just that. And I'm extremely honored to introduce our moderator and my old boss, Chief Justice Carlos Muñiz. The Chief is someone who has lived and worked according to our call to advance the common good. Before Governor DeSantis appointed him to the bench, he served as general counsel to Secretary Betsy DeVos of the United States Department of Education. And he's also served in just about every role an honorable and talented young government lawyer could dream in Florida state government, working for Attorney General Pam Bondi, the Florida House, the Department of Financial Services, and Governor Bush, just to name a few. A good man and an excellent jurist, of great honor and humility. I think I'd get the look if I bragged about him any further, but I'll say this and let him take it away. Us clerks often say among each other, and even to people that we've just met, that if we had to put the fate of the entire world in one person's hands, we'd choose Carlos Muñiz every time. So it's with the most confidence that I can say it's an honor to have him with us today and handling and moderating this panel. So please welcome our moderator, Chief Justice Carlos Muñiz.
Thank you, Chad. And that's a scary thought. I just want, for the record, to reflect Chad is no longer on the payroll, so he came up with that totally on his own. But Chad, I really appreciate it. I love my clerks. I've got the best team at the Supreme Court. I know there's other court clerks here who are also very happy and love their bosses and stuff, but I'm eternally grateful for you guys. So I appreciate the opportunity to be here. I really want to thank the organizers. I know we all feel that way. There are some of us who follow every kind of twist and turn in this debate, read every tweet, every article, every speech response that comes out. We don't assume that that's true for everyone. So let me just kind of briefly set the table before I turn it over to our panelists here. It's weird to say this given how timeless some of these issues are that are, that we're going to be talking about today. But in terms of, the path to us being here today debating this, I think started with a March 2022 Adrian Vermeule piece in The Atlantic called Beyond Originalism. And in that piece, he claimed that originalism was basically a politically and rhetorically useful construct that had outlived its utility, and that should be replaced with a substantive moral constitutionalism that would be founded on the idea that our whole view of law and of the Constitution should be based on the idea that the people governing us should have the authority, the power, and the duty to pursue the common good. There was some reaction to that. Adrian Vermeule decided to write a full book about it, setting out his idea. One of his kind of frequent co-authors on pieces related to this is Conor Casey, who's the first person we're going to be hearing from. But basically what he laid out in his book here, Common Good Constitutionalism, is kind of three separate things. The first is a theory of law. What he says is a theory of law as it really is, kind of an argument about the nature and purpose of law. The second is an argument about how that construct relates to the American tradition, the legal tradition, and the American Constitution. And then kind of a related third aspect is a very forceful, and I'll leave it to the panelists and for you guys to come to your own conclusions about how persuasive it is, but a very forceful critique of originalism, also a critique of progressive constitutionalism. But I think it's fair to say that the bulk of his energy and attention is focused on talking about originalism. So Professor Vermeule's book also got a big reaction. And I think it's generally considered, he's considered to have raised some important points. important enough that Judge Pryor, who I know a lot of us here are big fans of, has given a whole speech about it, or actually a couple of speeches, and turned those into articles. On the liberal side, the Balkanization blog has devoted a whole kind of symposium to it. There have been other reviews. The Harvard Journal of Law and Public Policy has devoted space to it. And, very serious, thoughtful academics kind of across the spectrum either have written about it or are in the process of writing about it. So we have a great panel here today to help us learn about this and think through it. First, immediately to my left is Conor Casey, who, as I mentioned, is a frequent co-author of Adrian Vermeule on this subject. He's a professor at the University of Liverpool School of Law. His scholarship is focused on comparative constitutional law and classical natural law theory. And in addition to writing with Adrian Vermeule, Conor has also written extensively on this subject independently. Next is Professor Jeff Pojanowski, who's a longtime professor at Notre Dame Law School. His scholarship covers the areas of ad law, jurisprudence, legal interpretation, and torts. He's written a really great article on the relationship between the classical natural law tradition and originalism. And I consider this as a compliment. I don't know if Jeff does, but although Adrian talks a lot about originalists in general and progressives in general, Jeff was one of the few people who Adrian in the book actually talks about specifically, and I'm sure we'll hear about, the agreement and disagreement there. So those of you who've read this book will know that he's, he gets a fair amount of attention in it. And finally, Nicole Garnett, who's a great friend of mine. We went to law school together. Also a longtime professor at Notre Dame. Her scholarship focuses on state con law, education law and policy, and property law. She teaches a very popular class at Notre Dame on originalism called Scalia versus Thomas, or Thomas versus Scalia. She's on the Federalist Society board of directors, and Nicole is the kind of person who considers it a compliment, I think, to be called a bloodthirsty originalist, like her boss, Clarence Thomas, right? So we thought that she would bring a great perspective to the debate, and to the discussion. So we'll hear from each of the panelists, and then I'll ask some questions, and then we'll save the last 15 minutes for questions from you guys. Thank you.
Thank you so much, Mr. Chief Justice, for the introduction, and to the organizers of this event for the invitation. It is truly an honor to be here. It's my first time in Tampa, and I'm absolutely loving it. And I'm very happy to be here on this very learned and, more importantly, exceptionally Irish panel. So I feel right at home. So in my remarks, I'll give a very brisk summary of 2 or 3 core precepts of common good constitutionalism. Then I'll try to clear away at least one misconception that is floating around about the tradition. But for a more fulsome account, I do recommend you get the book, Common Good Constitutionalism, or turn to an essay in the Harvard Journal of Law and Public Policy for just a more extensive account. So I'll outline a few core precepts. So the first thing to note about common good constitutionalism is that it's not an American phenomenon or practical results-oriented project. It is first and foremost a speculative project, a theory of the nature and purpose of law grounded in the classical natural law tradition of Aristotle, Cicero, Aquinas, and more recently the likes of Heinrich Riemann, Jacques Bartin, Charles de Koninck, and to a large extent, John Finnis. It's a theoretical outlook on law, transcending the particularities of specific legal systems and the time and context limited debates erupting within them. So it's primarily dedicated to reviving an immemorial way of thinking and conceiving of the purpose of law, including public law, and how they relate to human flourishing and the common good. In the classical tradition, of which common good constitutionalism is a part, the point and purpose of law and political authority is to secure the common good of the political community. Political authority is, on this account, regarded as natural and not presumptively suspect or a necessary evil to be tolerated, as in some liberal traditions. Living in a well-ordered political community in this tradition is considered a central feature of fulfilling man's nature as a rational animal with a normative and natural inclination to family, sociability, and political life. The common good itself in this tradition is, in simple terms, the highest temporal good of individuals. It is the structural, social, economic, political conditions of peace and order that allow individuals, their families, and part wholes of the community to genuinely flourish as the type of animals that we are. It is not a utilitarian account of the good that weighs up the happiness of the majority against a minority. It is an indivisible good that is not diminished in its being shared by each and all. It belongs jointly to all and severally to each. And this good, when participated in by individuals and families, elevates and perfects the individual's good and the family's good. So this account rejects many contemporary accounts of the purpose of law, including the idea that you hear perhaps from some classical liberal accounts that the purpose of law is to protect zones of autonomy for the mutual exercise of individual liberties, or in a progressive register for the state to create the social, economic, material conditions where everyone is free to affirmatively pursue their own conception of the good. It rejects both of these types of accounts. To count as law in its richest sense, in the classical account, in its focal sense, a law posited, a law created by political authority must rationally conduce to the good of the community for which the lawmaker has a duty and privilege of care. And just like how a dishonest friend is no true friend, but a very diluted version of a friend, quack medicine is not real medicine, but a kind of perversion of the practice of medicine. And like how illogical ramblings are not true arguments, but a sort of debased version of that, so too an unjust law, misfiring in this regard, is not a law in the richest sense of that social practice, but a diluted, impoverished version such that, while it may be called law and enforced as law by officials, is more akin from a normative perspective to the exercise of bare force. The classical tradition carefully distinguishes between two senses of law, lex and jus. So lex is the enacted law, the positive law, such as master text constitutions, statutes, executive orders, created by human authorities deliberately. Jus is the community's overall body of law that includes lex but transcends it. So lex, the law created by political authorities, is not exhaustive of a political community's law, because this law also contains general principles of jurisprudence flowing from the basic precepts of natural law and natural law's close relationship to human flourishing. So contrary to some caricatures of the natural law, posited law, created law, is absolutely critical to securing the common good and human flourishing. There are certain goods that can only be secured through the posited law. So law conduces to the common good in several ways. First, it specifies and makes concrete the open-ended and vague principles of natural law in each community. This is a process St. Thomas Aquinas calls determination, whereby political authorities make decisions to pursue human flourishing consistent with the natural law, guided but not dictated by right reason and the natural law. So, for example, the natural law might require a political community organize its law and policy in a way that is directed toward the flourishing of families, that respects subsidiarity and doesn't have a situation where the state unjustly interferes with the realm of family and community. It may demand organizing a fair economy, a just wage for just work, and peaceful relations with your other societies. The natural law may demand all of these things, but there will be countless ways to act consistently with all these charges, consistently with the natural law. The natural law doesn't dictate a single approach to either of them. Law is required to make more concrete these open-ended, vague principles. It requires a lot of creativity and discretion, guided by reason but not dictated. Law also serves a critical coordination function. It coordinates individuals, families, and associations in their pursuit of the constitutive conditions of the common goods, social, economic, and moral. It ensures their pursuit of these goods is done in an efficacious and harmonious way and not a chaotic way. Social unanimity is just simply impossible in a community of any complexity, and legal authority is required to solve coordination problems about what is to be done for the common good. And finally, law is regarded, and this is particularly scandalous to some progressive accounts of purpose of law, law is regarded as having a subsidiary but still important pedagogical function that is critical to ensuring citizens are oriented to the common good. Law does this by, for example, restraining evil and encouraging virtue conducive to the common good and human flourishing. And law does this in a bewildering variety of ways, from outright prohibiting certain behavior to exhorting against it, to encouraging certain forms of virtuous behavior or patterns of life via the dispersal of lucre and other state favors. Because positive law is not exhaustive of a community's law, but part of a wider juridical ordering to the common good, which includes the natural law, for the common good constitutionalists, in cases of ambiguity or where otherwise not clear, the classical tradition holds that officials should interpret positive law harmoniously with principles of the natural law, with principles of use, to ensure the positive law remains true to its purpose, its telos, of serving as a reasoned ordinance for the common good, and is not allowed to misfire and to devolve into a perversion of law. Finally, common good constitutionalism does not endorse a particular form of regime. It says that the common good is not contingent on endorsement of, say, a presidential system, parliamentary, monarchical, republic, nor does common good constitutionalism demand particular institutional configurations of power that include strong judicial review, for example. These kinds of questions aren't dictated by the natural law whatsoever. They're prudential ones to be approached by constitutional designers with a orientation to structuring your constitutional institutions to make sure they're aptly structured, suitably constrained, and suitably empowered to act to secure the common good. And finally, just one misconception that you may have heard. You may have heard common good constitutionalism sort of commands judges to set aside the meaning of positive law fixed by a legitimate authority, whether it's a constituent authority establishing a constitution or a legislature lawmaking by creating statutes, to set them aside in favor of what the judge thinks might better map morality. But this is not the case. Common good constitutionalism is emphatically approached to interpreting positive law, consistent with the immense respect the classical tradition has shown for positive law and its indispensability to the common good, respect stressed by leading natural law theorists like Finnis, Maris Kopke, and my colleague Jeff here. The classical lawyer will accept that legal practice will and should largely be conducted through a thick web of interpretive rules, doctrines, presumptions, through the artificial reason of legal argumentation, as Edward Cook called it, and not first principles moral reasoning. So the classical lawyer can argue without difficulty that, for instance, most statutory cases can be dealt with by interpretive rules commanding some form of plain meaning textualism. They can entirely accept a large run of cases will not be dealt with via direct recourse to principles of natural law. But, and this is critical, the classical lawyer will not justify these kinds of doctrines like presumptive textualism, by boldly stipulating that the plain meaning of a statute or constitutional provision is exhaustive of a community's law, that lex is all there is and there's nothing else. Rather, they will regard such doctrines as determinations, apt to coordinate the complex enterprise of legal practice in a manner conducive to the common good, because these kinds of doctrines help generate goods like legal predictability, legal continuity, stability, and respect for legitimate authority. Also critical is that while classical lawyers understand the great run of ordinary cases can be decided without direct recourse to principles of natural law, they're equally emphatic these principles can never entirely be excluded from interpretation of legal materials. In hard cases, which are particularly rife in constitutional law due to the limits of founders' foresight and the inevitable ambiguities and open texture of language, especially morally laden language like liberty, general welfare, common good, the classical lawyer affirms that in these types of hard cases, legal materials must inescapably be interpreted in light of background principles of political morality and rejects the illusion that this is avoidable. For the natural lawyer, the principles that should be relied upon to help interpret the meaning of lex where it is ambiguous are principles of the natural law themselves, ipso iure, part of the legal system. And they include things like moral absolutes, excluding the intentional killing of the innocent, intentional mutilation of the person, or the kind of enslavement or degradation which treats a human person as an object or a lower rank of being than the autonomous, rational human subject. So common good constitutionalists, to finish up, they're committed to interpreting, not displacing positive law. They're committed to discerning the reasoned choice of legitimate authority in choosing to posit in law what they did in constitutional text, to understand the mischief they took themselves to be addressing or not addressing. It never devolves into the subjective exercise of all things considered moral decision-making. Judges have neither the jurisdiction or responsibility for. But in hard cases, the classical lawyer says the decisions of public authorities must be considered in light of the wider legal order it's a part of, and where possible, harmonized with that wider legal order, where at all possible. So I will leave it there. I ran over a little bit, but happy to answer any questions in the Q&A. Thank you very much.
All right. Well, thank you, Conor. So I'm here to talk a little bit about why the classical natural law tradition and originalism are two great tastes that taste great together. So first, I want to point points of agreement with Conor here. If you're a classical natural lawyer like myself, you read common good constitutionalism. It says the law should be seen as a reasoned ordering to the common good of a flourishing political community by political officials who act in a manner consistent with the requirements of their particular roles. And I'm like, that's great. I agree with that. That's what good, reasonable, rational government should do. Now, as Conor explains, and here we agree, the natural law underdetermines, doesn't give precise answers about how a particular political community should order itself. And consensus on that will often be impossible. We all can't just have a constitution by convention and assume we'll all agree about who gets to be an officer and what rights we have are. So what matters, though, is making choices within the range of reasonable options that the natural law provides, and that's congruent with the kind of the frame and the character of the people, right? And so constitutions are necessary for doing this. Constitution making is reasoned action and decision making. The framers get together and said, okay, we need law. It's not enough to say we need law. We need a government that makes these rules. And we need to figure out who gets to be an officer and what the rights are and stuff like that. And there's no code book in the sky of the natural law telling you what your constitution should be. So we got to pick something, and you got to pick a reasonable one that kind of roughly fits your polity. And so this points to the moral need for determination. Determining a particular choice. Are we going to be Federalist? Are we going to be centralized? Are we going to have presidential or parliamentary, et cetera? So someone needs to make a choice, and those choices need to be authoritative and enduring. It's not enough to say, okay, well, we decided we're going to have federalism now, and then we'll just kind of move on to something else later on down the road. The whole point is you need to kind of fix a choice to kind of get the operation system up and running, right? So I think Conor and I are largely, in agreement on that. There are obviously some constitutions that are not worth following or worth having, but there's going to be a wide range of reasonable constitutional orders. Now, why originalism or something like originalism in legal interpretation? I'm thinking here primarily as a judge, but any kind of legal official enforcing the law, whether it's a police officer or an administrative agency officer or something along those lines. We'd say, well, look, given the moral need for a political community to make determining authoritative choices, the point of faithful interpretation is to identify what that reasoned choice was, or to the extent you can. And to do that, you go back to the origins. What choice did the framers make at this particular time? That by treating that original law as enduring and fixed until changed by whatever process we otherwise agreed to, it empowers what's distinctive about law and how it works and the moral benefit that it brings to a community. So you've asked framers to put together a system of law. You should go back and look to see what they did if you're going to get the benefits of law. Otherwise, why ask them to do it in the first place, right? Now, this doesn't mean the answer to every question is going to be a neat, clean rule, or that doesn't mean that every question of interpretation will be easy or that there's no judgment, but it does set the goal. It's what you're seeking to try to identify when you're asked to interpret something like the Constitution or a statute or what have you. Now, it doesn't also mean the interpretation of original law will govern every case that's adjudicated. Courts do lots of things besides interpretation. And there's other law on the books besides the original law of the Constitution. You've got precedent, you've got rules of adjudication, rules of party presentation. There's a whole bunch of law out there, right? And there's tricky questions about what do you do about non-originalist precedent and all the other law in the books there. But the bottom line here is interpretation of the original law of the Constitution is the orienting anchor in adjudication when the court's asked to interpret. And even if there's non-originalist law in play, even if you have bad non-originalist precedent, so to speak, original law can claim a special status. It can kind of return from the sidelines. It's never truly entirely gone unless you kind of change the constitutional system. Now, this is not to say that you should be an originalist about necessarily every constitution. You could be an originalist about the Constitution of North Korea, but that probably wouldn't be something worth your time in light of the natural law tradition, right? We seek original law because we want to promote the common good and human flourishing and coordination. And if it's a wicked system, it's not worth being originalist about it, right? But if you think that if the Constitution is reasonably just and good enough for government work, then there's a strong moral argument for being an originalist. And so most of the stuff you all do as lawyers or judges, this kind of technical legal stuff, historical and doctrinal work in the weeds, is how ordinary officials implement the general principles of the natural law that have been made specific in a particular political community. You can think of kind of like natural law, justice, and work clothes. You're not thinking about the natural law all the time, but you're doing the kind of, a bunch of people have made rules and law and doctrines that kind of implement the natural law in this particular community, and you're helping that system operate. And that system operates best, and we get if we kind of go back and look to try to understand what was fixed. Now, what are some possible objections to this approach? And I think my disagreement with Conor and his friend Adrian, I think maybe slightly differences in degree here. But one possible objection is that something like originalist interpretation is impossible. You can't interpret without engaging in moral questions. You can't understand the lex, positive law without looking to moral backdrops. And I think one response would be that, well, it depends what you mean about morality. Like, so on one level, I agree. So I've offered a kind of moral or normative argument for originalist approaches to interpretation for moral reasons. The best way to realize the common good and human flourishing is to get the coordinating benefits of law by looking back to what's been done. Otherwise, we can't run the system. There's many ways you can choose to interpret, and the way you're going to choose to interpret is partially going to be based on what you think a good way of doing things is, right? And if you don't buy that moral argument, you want to interpret a different way. But I'm making a moral argument for a particular method. So yes, there's no such thing as neutral interpretation. All ways of going about to interpret a document are informed by what's the best way to kind of operate the legal system, or what the best way to do things are. A stronger objection, or a place where there's a little bit more, I think, more disagreement, might be at the level of positive law. In other words, it's to what extent can you interpret a particular provision of the Constitution while excluding kind of first order moral considerations? Can you understand the due process clause without engaging in moral inquiry? And here, I think Conor and I probably disagree at a level of degree. So think of a situation in which you found the best reading of the formal law in a somewhat tricky case that doesn't go along with what you think your political priors are, right? There's an instance possibly of, well, I can identify what I think is right and important, what the law requires here, even if it's not what I would have chosen in the first place. At that level, I can kind of interpret without kind of bringing my moral judgment to bear. So can that be done? If people say, again, is infant baptism possible? You say, well, yes, I've seen it done. Here, it might be like that with interpretation. And the same goes, I think, and I think for at some level, I think advocates of common good constitutionalism have to agree with that. Determination and role morality are important for them. And if we can't fix choices through positive law, or hive off roles through positive law, it's hard to get the benefits of law that we agree on. What did a judge or administrative agency decide? We have to kind of identify what the as a matter of history, what they've decided. Now, if our distinction is just kind of what do you do in hard cases, then we may not have that much of a disagreement. I don't think an originalist is compelled to think that originalism solves every question neatly and cleanly. There's some kind of questions of judgment, and you have to kind of look to moral considerations. I think we just may be possibly disagreeing on the range of hard cases or what counts as a hard case. So that's one objection. Another objection may be originalist interpretation leads to bad results. We can go back to my North Korean example as an extreme example. You could be an originalist about the Constitution in North Korea. I don't recommend it. I think there's better things to be doing with your life than being an originalist judge and the People's Democratic Republic of North Korea, right? So on the other hand, and you can imagine a more muted version of that. You could say, look, our original Constitution is deeply problematic, and you can view that from a number of different ways. You can say it's too libertarian, it's too clunky, it's too hard to make law, it's too hostile to the administrative state. Its origins are in racism. Pick whatever objection you have, and you can say, well, to the extent those outputs kind of lead to something bad, it's not a game I'd want to play. Well, first we want to, the proof is in the pudding. You have to see if the original Constitution does all the bad things you might think it does. But even if it does, my threshold for departure is pretty high. I kind of I'll probably scandalize you. I scandalize my students' jurisprudence where I say, I think probably the American Revolution was probably unjust. I think things were good enough. I probably would have been a Tory. I would have stuck around. I think stability is a good thing. And so even if there's a whole bunch of stuff in the Constitution I'm not crazy about, I think the moral benefits of settlement and coordination and positive law are good enough. And then another subspecies of the originalist interpretation is bad is it's disruptive. We're going to blow up the administrative state. We're going to overrule things that are 70, 80 years old. Pojanowski, you've been talking about settlement and stability, and you want to kind of come in and blow everything up because we've got 50 or 60 years of non-originalist precedent. What kind of stability is that, right? And, well, first off, originalists there is an ongoing argument among originalists about what you do about precedent. There's arguments that the Article 3 judicial power includes some consideration of precedent, and there's some stabilizing forces. And then it's just a kind of question of how much disruption is bad, and how do we think about the costs of not being faithful to the Constitution that we've been laid down and giving people incentives to depart further from it, as opposed to the disruptive that we have on the ground. So I'll conclude. So what's good? What could a person like me who's friendly to originalism give kind of 3 cheers for about common good constitutionalism? And the first is it recognizes that constitutionalism and constitutional interpretation is ultimately a moral enterprise. We're not just doing law for law's sake. We have law for reasons to promote the common good, human flourishing, protect individual rights. And even when you're doing boring technical legal stuff, following rules that you think you found or laid down, you're not just doing law. You may be doing law, kind of doing ordinary boring law on the first level, but on the second level, you're upholding an important system, and the way you go about doing that kind of first order stuff is going to be informed by moral reasons. It's not law all the way up. At some point, there's got to be kind of a moral hook that it hangs on. And one possible point of disagreement, and again, this may vary in the hands of of what common good constitutionalist interpreter we're having, is worries about insufficient respect for the constitutional order we have. Being too quick to read the broad generalities of the Constitution, like the General Welfare Clause or the Due Process Clause, as triggers to engage in moral inquiry, as opposed to something that there could be an actual kind of more particular or firm rule settled behind. Too quick to find ambiguity, too quick to find uncertainty, to appeal to non-posited moral principles. And so that's probably where I think Conor and I would have some disagreement. But I'll stop now and yield to my friend Nicole.
Thank you. So my family has been in this country since long before the revolution, and we were decidedly patriots. I also When I arrived at the Marriott yesterday, the first thing I did was march up to the desk of the Moms for Liberty and buy a T-shirt. I also think I should tell you that in the interest of full disclosure, according to a recent New York Times op-ed written by my neighbor, Pat Deneen, members of the Federalist Society and the conservative legal movement more generally are jackals of mammon. And I am here speaking on my own behalf and not on behalf of the Federalist Society, but I am a lifelong member of the Federalist Society, and I just joined the board of directors, so I think that kind of makes me like a henchman of the jackals of mammon.
Alpha wolf, yeah.
I don't like being called satanic, but I'm unapologetic about my involvement in the conservative legal movement and the Federalist Society. And I actually, my talk is going to be a lot more practical than theoretical, and it's going to be very focused on what I take to be one of the big motivating factors for both the common good critique, but also why it's attractive to young people like you, which is a sense that the conservative legal movement failed, that there's something wrong with originalism and textualism. And I'm really unapologetic about my adherence to the principles of the conservative legal movement in the United States in particular. I don't have any, I'm not a comparativist, so I don't speak about I can't say much about North Korea. But I do want to talk to you a little bit about why. And I also want to talk to you about, in particular, just a reminder of what the conservative legal movement has accomplished for the rule of law in this great country and the American constitutional order. And these accomplishments, I think, are all too often dismissed, denied, and maligned by common good constitutionalists, particularly on Twitter. And I think in many ways the critique, at least as it's known in the public sphere, and maybe to you as people who are like me, on the edges of this debate, really are a critique of conservative legal principles and originalism in particular. I want to start by pointing out that I don't think we'd be having this conversation if it was not for the accomplishments of the conservative legal movement. We would not without the doctrinal and methodological developments that this has accomplished, we would be having a very different conversation. So I'm going to set forth in the United States what I consider to be the foundational principles of the conservative legal movement: respect for the rule of law and fidelity to the American constitutional order, limited government, federalism, separation of powers, and a belief that the law is what the law says, which is to say fidelity to text, originalism, and textualism. I think to a greater or lesser extent, many common good constitutionalists reject many of these principles to varying degrees, or perhaps redefine them to the point where they're unrecognizable. Ultimately, although perhaps they say that there's a lot of respect is due to text, ultimately they would give or perhaps require judges and bureaucrats to substitute their understanding of the common good for the text and for the will of the people. I think this approach is contrary to a written constitution, and it is dangerous business. And I'm also pretty sure that we would all still be wearing masks if Adrian Vermeule's view of the administrative state prevailed. I assume most of us welcomed and celebrated Dobbs. I think Dobbs put to rest the argument that the conservative legal movement has failed. I think it is unquestionably the crowning achievement of the conservative legal movement, and it is made possible by decades of doctrinal development that enshrined these principles that I just described and promoted the appointment of judges who ascribed to them, which led 5 justices to literally risk their lives to divest the court of authority over abortion. And God bless them. But I'd like to return to the years leading up to Roe. Specifically, I would like to return to 1972, the year that Bill Rehnquist was appointed to the Supreme Court. At this time, the court lived in common good land. It had abandoned any real pretense of doing law. It created rights whole cloth out of thin air, finding them magically in the penumbras and emanations of constitutional vibes. It authorized federal courts to wrest control and run our public institutions through structural injunctions. It elevated legislative intent and legislative history over text. It invented balancing regimes like the Lemon Test that had nothing to do with the Constitution, and it tied the hands of law enforcement with ahistorical criminal procedure rules. The list goes on and on. The court was systematically getting everything wrong because it had systematically stopped asking the right question. The right question is, what does the Constitution mean? And it's taken instead to asking the wrong question, which is, what should the Constitution mean? So after his confirmation, the years following his confirmation, Rehnquist cast a number of critical votes, deciding votes in cases that in some ways saved the Republic, in my view. Think about the three. San Antonio versus Rodriguez in 1973 held that poverty was not a suspect class and that education was not a fundamental right. Milliken versus Bradley, 1974, held that federal courts could not dissolve over 50 school district boundaries and assume control of running public education in all of the Detroit area in order to achieve racial integration. Washington versus Davis in 1977, which held that in establishing a violation of the Equal Protection Clause requires proof of intentional discrimination and not just disparate impact. Had these cases gone the other way, and without Bill Rehnquist they might have, we would be living in a much different legal world, and in a world closer to the ideals of common good constitutionalism, where federal courts would be finding, perhaps on natural law justifications or whatever others, more rights. Why stop at education? What about food, shelter, housing, income? All those things seem important to me. What about more suspect classes? Why stop at poverty? What about age, marital status, disability, sexual orientation? And since every government action has a disparate impact on someone, absent Washington versus Davis, every government action would be arguably unconstitutional, and federal courts would be forced to step in and remedy these imagined violations. District judges exercising their whims and views of the common good would be exercising their remedial power to run our public institutions. Thank God for Justice Rehnquist. In 1986, Justice Scalia joined Justice Rehnquist in his fight to restore order to our law. Before then, Justice Rehnquist liked to call himself the Lone Ranger. 5 years later, Justice Thomas joined the court, and together they began to make the case, often in dissent, that fidelity to the Constitution requires not just Rehnquist's characteristic judicial restraint, but originalist and textualist methodology as well. To make a very long story short, these three men helped cement in our federal law the idea that words matter, history matters, and structure matters. That the Constitution is not and should never become, again, a roving mandate to do good. Their opinions, together with the efforts of the Federalist Society and others in the conservative legal movement, have changed the way federal courts do law, so much so that even Justice Kagan has quipped that we are all originalists and textualists now. So thanks to the conservative legal movement, the first question in any federal case today, should be, often, mostly is, what does the law say? And the second is, what do these words mean? Questions about what the law ought to say or what a just order should require or prohibit are largely vanquished from our federal courts. And that is a good thing, because these questions are a roving mandate for mischief. None of this is to say that judges, even conservative ones, don't make mistakes. Of course they do. See Bostock. But we should not confuse, as often I think we do in these conversations, bad originalism and bad textualism with originalism and textualism being bad. Nor is it to say that originalism and textualism are easy, or that even if done right, they necessarily produce conservative results. They do not. Justice Thomas once observed in Bennis versus Michigan, the federal Constitution does not prohibit everything that is intensely undesirable. For those who don't believe me about the value of these conservative legal principles and the methodological commitments that flow from them, I would commend to you the way that constitutional law gets done in many state courts. Now, I know there's a lot of state judges here. I'm sure that you were not guilty. But these principles, I teach state con law, so I am familiar. I love teaching state constitutional law. These principles and methodologies in many state courts have taken hold to a much lesser extent. I hope that is changing with Justice Muñiz and others. But in many state courts, judges openly engage in something approximating common good constitutionalism. It continues to amaze me how often when I'm teaching state con law cases, the text and history have nothing to do with the outcome of constitutional claims. Give a couple of examples. In my home state of Kansas, the Supreme Court found a right to abortion in a natural rights clause of the state constitution that effectively restated the Declaration of Independence, because abortion is good. And here in Florida, in Bush versus Holmes, which you probably know, the state Supreme Court invalidated a voucher law on the grounds that it offended the guarantee of a uniform system of public education. despite the fact that the Florida Constitution explicitly authorizes the states to advance the goals of public education by means other than public schools. Public schools are good. And these decisions are just two among literally hundreds of state court opinions relying on public interest to trump the text and history of written law. In fact, many state Supreme Courts explicitly make advancing the public interest, you might substitute the common good, advancing the public interest, one of several factors relevant to legal interpretation, often the factor that swallows all others. Perhaps if they were better natural lawyers, we would come to better results, but I have some doubts about that ability of judges to really decide that which natural law principles to trump the text of state constitutions or federal ones. This is, in my view, a lawless world and is not a world that conservatives ought to want to live in. Sometimes I think, particularly among my students, I sense there's this year has been a good term, probably the best conservative legal term in the history of the Supreme Court, but there's just a frustration that we feel like you've been promised so much and nobody's delivering. So we just need to start winning. And I don't say that is in fact, that may be a caricature of common good constitutionalism, but it is the character I think that gets embraced often by young conservatives. And this, I will tell you, is not a winning strategy. It is a one-way ratchet toward an ever more progressive world order. So Justice Scalia, as Justice Muñiz points out, once described my old boss, Justice Thomas, as a bloodthirsty originalist. And I am proud to count myself in that camp. And I think perhaps I was brought here not to give you a lecture about the merits of the conservative legal movement, but I mean, I have tenure, so I can do whatever I want. I think my appointed job here was to explain why I'm a bloodthirsty originalist, and I'm going to make my answers short. I am an originalist for two reasons. The first, over a decade ago, when Justice Thomas published his memoir, my grandfather's son, my husband and I attended a book event in Chicago in a big, crowded hotel ballroom, and an old man stood up and asked the justice why he was an originalist. And Justice Thomas replied, well, I took an oath to uphold the Constitution, and the way I see it is that you can either do the hard work to understand what the words in the Constitution meant to the people who ratified them, or you can make it up. That's the first reason I'm an originalist. And here's the second. Having seen the alternative in action, we should know better. Thank you.
Okay, so I'm sure Conor wants to respond to that, but just to make it, in the interest of maybe making it a little bit more interesting before we get to Conor, Jeff, do you agree that common good constitutionalism, as advocated by Conor and Adrian, is there nothing within the structure itself of common good constitutionalism that would prevent the sort of dystopia that Nicole talked about, with essentially reading sort of progressive moral views into the Constitution without being able to say that there's anything wrong with that?
Yeah, so I have to confess, in this, I find Adrian's book tricky in this respect. So the opening chapter speaks of general principles of constitutionalism, which includes the benefits of positive law and division of functions and special responsibilities among the judges. And I pick up with that and run and say, yes, and therefore something like originalism, right? Understanding, what the positive law originally meant and how it was fixed. And so my buddy Kevin and I are working on a review of Adrian's book, and there's generic common good constitutionalism, like this is the framework, right? And that kind of framework can support something like originalism, and that's where I take it, right? On the other hand, when at least with Adrian's book, much of the affirmative case of what his constitution, the way he specifies his generic version of common good constitutionalism, it looks very different than the originalist constitution, and maybe because he argues that there's open-ended things in the text that says this is okay and this is permissible, and so I think it's possible to kind of take the classical legal tradition and bring it into something very much like an originalist order. That like Kevin and I are working on and doing that, right? But there are the reasons, but if you kind of take it in another direction, you can go towards being the more Ronald Dworkin like you are, the bigger the risks that you have for some of the stuff Nicole is worried about and concerned about. So it's hard to say.
Just three points. One is, you can probably tell by my accent, I'm not American. I'm engaged to a Kansas City native, so I have very fond feelings for the country. But so my interest in this debate is, I not that I don't care about the practical results, but I'm not. I'm not attracted to the theory because I think it's a very good crib sheet for federal judges to wheel out now that the bench is well stocked after the Trump administration. That does not interest me. I think first and foremost this is a speculative project of the nature of law, getting your understanding of the point of law and the different senses of law that order a community, written text, and the natural law. And if you're a natural lawyer, you will think that that is a very important aspect of the enterprise of having a legal system. So that's first and foremost. The practical results are, if that's not the primary motivation. The second thing to say is that common good constitutionalists, like any classical lawyers, it is about, I don't know many lawyers, especially natural lawyers, who say that they're not devoted to understanding the meaning of the posited law. That's what they want to find out. That the fighting question is how you ascertain the meaning of it. And I think Jeff might agree, based on enduring originalism, that it's not self-evident. It doesn't self-evidently follow when you say you're trying to faithfully interpret the meaning that you leap to saying it's the understanding of the average person around the time it was adopted. Why that? Why not the original intent? Why not the intent of the lawmaker deliberately acting in a certain way to change the law? It doesn't tell when you trying to follow the original meaning. There are choices you have to make that are not self-evident. What level of generality do you read the text? Do you apply the text like a member of the founding generation would, the reasonable citizen who ratified? Or do you apply it as an abstract principle? And how broad does that principle go? Do you go as far as Jack Balkin and say, you read originalism in a very general way so that principles like liberty can be understood to evolve, to encompass, moral developments? These questions aren't self-evident, and just saying that you're following the original meaning doesn't do the work that you needed to. You need to make moral choices to prioritize original understanding over intent, to read a certain level of generality and not another. Do you rely on the party presenting the historical record, or do your own, and so on and so forth? And the only way to make these decisions is to prioritize some things and not others, and those are moral choices. So I think originalists bring that to bear in interpretation, and classical lawyers do the same. They're all in the same enterprise of trying to faithfully find the meaning of law. The fighting question is, how best do you do that? And for the classical lawyer, the lex, the posited law, is a determination of higher law and should be harmonized with it. And that's the way they think that law should be respected. Posited law, its meaning should be found. And originalists have another approach, but they're engaged in the same enterprise. And moral reasoning informs both. So I think to say that one is a disinterested search for the meaning of the law and the other is not, I don't think that's, I think they're engaged in the same enterprise. And the third point is, any theory can be taken and twisted and abused. I mean, I bet there are many originalists here who are, quite perturbed at Jack Balkin's living originalism. he can, in good faith, say that he's trying to find the original meaning, but the original meaning embodies abstract principles like liberty, and that you can read that clause to embody something like a anti-subordination principle, and that implies, you have to have legal abortion or gay marriage or something like that. And that's all in good faith. He can argue that entirely, and I'm sure originalists would think you're kind of twisting it or not being, you're not doing it right. And for the common good constitutionalist, if it was someone took it and ran with the language and did things totally contrary to natural law, use it as a progressive instrument or whatever, they would say the same thing. They would say anyone can twist a theory.
So, Conor, let me ask you, I think one of the things that gave some momentum to common good constitutionalism that was the timing of Adrian's article and the original one and the Bostick decision, which came out a couple of months later. Then in the book, when he talks about Bostick, it seems like he acknowledges that the dissents by Alito and Kavanaugh give arguments for why Bostick was bad textualism. But Adrian seems dissatisfied with that. And I'm wondering, but he also says that Bostick was obviously wrong. And I'm wondering, why is Bostick bad common good constitutionalism, in addition to arguably being bad textualism?
So I, again, not being American, I have a high-level understanding of Bostock interpretation of Title VII, sex discrimination.
Right. No, but do you agree that Bostick was obviously wrong?
Yeah.
Okay.
I mean, I think the point being made about Bostock was that Gorsuch, the dissent and the majority were both engaged in the activity of finding the posited meaning. They're both trying to faithfully interpret the law, but both had to make choices about how to precisely do that. Do you interpret the law as when you're trying to find the plain meaning at the time of adoption? Do you read it like the drafters would have understood it? Do you read it as any member of the public at that time?
So how would a common good constitutionalist, and I know that was a statutory case, but what question? So it seems like both the majority and the dissent were asking themselves, what do these words mean? Gorsuch said they mean sex discrimination includes these other types. The dissenter said no one would have thought that. So what question is the common good constitutionalist asking himself?
Yeah, as I said, common good constitutionalists would accept that the large run of cases should be determined through the artificial reason of law, through doctrines, and a doctrine that you could justify on grounds that this doctrine, when adhered to, conduces to stability, certainty, predictability, is a form of plain meaning textualism. And if you do adopt that kind of approach in a case like Bostock, I would think that'd be an easy case, that the plain meaning, that if both in terms of how it would be applied, expected applications approach, and in terms of how it would just be generally understood by the reasonable observer, what kind of change it brought into law. No one would have understood it in either of those applications as getting to the majority result.
Which is kind of puzzling, though, because it's Bostock is invoked as in the book as a reason why one kind of the bankruptcies of like originalism or textualism or something like that, or why we need something like common good constitutionalism. If plain meaning textualism supports what Kavanaugh is doing in the dissent, that kind of saps at least so there's so much motivating energy in the book out of Bostock, and an originalist or a textualist would say, well, that's just bad textualism, right? And then Professor Vermeule's replies like, well, look, if even Justice Gorsuch can't do good textualism, this is not going to get us anywhere. So therefore, this is an unmanageable, unstable kind of system. Which goes back to Conor's point that like any theory can be abused, right? I could take common good constitutionalism and run it all the way you guys don't want to, or I could do it the right way. That may not, Conor's arguing, well, that's not an argument against common good constitutionalism. That's a good argument against any theory. Well, I think the same thing applies with respect to originalism and textualism. Just because Gorsuch screwed it up by hypothesis here, and I think he did get it wrong, I don't think that's an argument against textualism or originalism. I think it's an argument against bad textualism and bad originalism. So.
Nicole, let me ask you. You mentioned the Kagan "We're all originalists" quote, and after the Ketanji Brown Jackson hearing, where she, I guess, in some sense, professed to be an originalist in the sense of adhering to the meaning of the text. We all know people think that means different things when you're looking at different texts. But where do you come down? Among conservatives, that sparked a big debate. I think the Agent Vermeules of the world say, if they're originalists, then who cares about originalism anymore?
Well,
where do you come down on that?
I mean, Jack Wilkins, I don't care what he calls himself. He's not an originalist. I mean, I do think so I think to Conor's point about there's two problems. I mean, the first one is the levels of generality problem. I mean, you can define originalism out of existence by making I guess, a capacious liberty principle that really does mean the natural rights clause of the Kansas Constitution includes a capacious right to abortion, even though the good people, the good freedom-loving Kansans, the Jayhawkers did not intend that and did not think that those words meant a right to abortion. I mean, you can define it away. So I would probably have a different understanding of what originalism is that would have a very narrow zone of construction to none, right? That's a different debate about among originalists, which I think is an important one. But as for is Ketanji Brown Jackson or Legan Kagan for that matter an originalist? Probably not. But I do think Legan Kagan is some version of a textualist. My point in saying that is not to say that Ketanji Jackson. I don't know why I should know which order the names are in, but anyway, the newest justice, she's not she I doubt is an originalist, but I just think it's important to point out how much the law has changed. So the questions that get asked first are what the law says and not what the law ought to say or whether let's figure out what the vibe of the thing is and then come up with some rule that has nothing to do with anything else to implement it. Judge Dearman O'Scanlan, who is an amazing human being, he was educated in the 50s, and he has a talk he gives to Federalist Societies where he says, you don't even understand how different the world that you live in is compared to what I was taught in law school, where it really wasn't, the beginning of the question wasn't what the text is. So I think that is what I'm trying to say, the beginning, the starting point is originalism and textualism. And we can fight, about what the memorial and remonstrance meant or something like that. But I just think that the great triumph of the conservative legal movement is to get the federal courts to ask first, to start first with the text, and then proceed from there, rather than starting with the vibe and proceed from there. So I think that's a great triumph. And I'm not saying that Professor Casey doesn't think that that the common good constitutionalists don't first start with the text. But I think that for many, many young people, they have forgotten or never really remembered what the alternative to a world that is fully informed by and influenced by the principles of the conservative legal movement is. I think it's just an important thing. For me, at least, it's an important thing to emphasize.
Great. Okay, and I'm going to ask Conor one last question so that we can leave time for the audience. So last night I read a review of Common Good Constitutionalism by a progressive who said, I can't remember if it was a she or a he, but they were critical of some aspects of Common Good Constitutionalism. But as for abortion, they said that they felt comfortable with it because they were confident that they could articulate a common good rationale for robust protection of abortion rights. And I'm curious whether you believe, in terms of your understanding of the natural law and this philosophy here, could you purport to be making a determination of the natural law and enshrine in positive law a protection of abortion rights? Or would common good constitutionalism say that is objectively not a permissible choice for the lawmaker?
So the common good or the natural law isn't just what the judge thinks
Or
It
what
is.
the legislator thinks, right?
Or what the legislature thinks, yes.
Or the people if they're adopting a constitutional provision.
Yes. So
Objectively, yes or no? Can you have? And I'm only doing this because I want to make sure I leave time for you guys. Could a common good legislator say, I want to enshrine in positive law a right to abortion and be doing it right?
it would always be whether they would have authority in a sort of intra-system sense.
So there's nothing about the natural law that would take that off the table.
No, the natural law would always say that would be a perversion of law, and that would always be a reason for justifying non-compliance with the law or an official refusing to maybe adjudicate a case or whatever.
And so if that law were put into the Constitution or on the books, could a common good constitutionalist judge invoke the higher law principles as a reason for interpreting it out of existence?
That's a very hard question.
Okay.
And,
right,
we had that case in Ireland, actually. We had a example of that. And I would say that the classical tradition does not have a single answer to that. That's a question of determination. It'll always be considered a perversion of law, something like that, but whether it gives a particular official, like a judge, authority to invalidate is a separate question. And I don't think the natural law dictates it, because Aquinas himself said, he never said an unjust law is not a law. He said an unjust law seems to be a perversion of a law, which seems to countenance the idea that you can have positive laws enforced as law, but they're actually perversions of law. So he countenanced that would happen. So I think the natural law does not dictate an answer to that kind of, but I think that's I think most constitutions, most provisions in them can be harmonized with principles of use. You'd have to look very hard and find a very particularly perverse provision before it couldn't be reconciled.
Okay. Audience questions.
Hi, thank you so much for being here. I'd like to know whether you think that common good constitutionalism is morally relativist or morally objectivist. So, for example, when faced with the textual ambiguity, would a common good constitutionalist look to historically American moral values, at least when considering an American text, or would the constitutionalist look to more general human values, which, due to the difficulty in obtaining a global consensus, are just difficult to obtain and might be different from American values?
Yeah, thank you so much. I think there's a moral realism to common good constitutionalism to get it off the ground. If there's no natural law, then it just collapses, and there's no reason for adhering to it whatsoever. So it's universal in the sense that it works out from core precepts of the natural law. I'm not a philosopher or theologian, but most natural lawyers think that includes prohibitions against intentional taking of life, mutilation, enslavement, and it puts affirmative obligations to promote family, rearing and education of new life, and peaceful social order and things like that. So there are core precepts which you cannot act against, and there are positive obligations you have to act for. So they're universals, but the particularization of those principles will vary wildly depending on the country, the people, the temperament, the climate, things like that. So custom and tradition are very important to look to, but you need a yardstick to measure the custom and tradition against. Tradition is not just good for its own sake. You can have very bad traditions, but a long-standing tradition which is consistent with universal precepts has an extra force because it commends itself to that particular people. So it's kind of a mix of the universal and the particular, as long as the particular isn't a perversion of the universal principles.
Sure. So, and just as a follow-up, so I think you would say if a common good constitutionalist didn't really think that the values of that person's people were morally just, you would say that the common good constitutionalist should diverge from what that person thinks his people or her people would want.
Just in broad terms, say a legislature empowered to sort of make general rules for the community prospectively and things like that. If a tradition is, a perverse tradition, then that should have little weight in the practical deliberations of that legislature, because it has no moral weight if it's a perverse tradition. But if it was a tradition that is consistent with those kind of universal natural law precepts, there's good reason to respect the custom and tradition of a people that's long established.
Thank you.
Hi. It seems to me that we're conflating.
A little louder, please.
Well, a little closer then. It seems to me that we are comparing a little apples to oranges when we're just debating common good constitutionalism and comparing it to originalism, which is an interpretation theory as opposed to a construction or more broadly construed theory about how constitutions work. So, and that's why it's been so squirmish to get a commitment from you on an interpretation theory, I think. But generally speaking, I have 1,000 questions. I'll only ask one because I have someone here. How does common good constitutionalism guard against constitutional evil, just generally, as compared to with whatever interpretation theory it has or it is compatible with, as opposed to originalism, which, for all its vices, including Jack Balkan in that club, still has a limiting principle, which is meaning, whether it's at the highest level, semantic, broadest meaning, a general level of generality, or expected applications. So what is the limiting principle in whatever interpretive theories are compatible with your constitutionalist theory?
Yeah, so common good constitutionalism starts out very high level. And I said that determinations have to be made. There's to an extent, the common good constitutionalism agrees with, say, Sunstein in saying there's nothing that faithful interpretation just is. You need to justify the choices you make. You need to justify the doctrines you make. But the common good constitutionalists would, you could have different forms of interpretation that are your first cut at interpretation, that don't have direct recourse to natural law principles. Adrian's very fond of a presumptive form of textualism, also fond of theory and deference, giving the legislature the first cut and judges to defer. I am fond of Professor Richard Eakins' understanding the Lawmakers Act as an intentional act. You're trying to ascertain the reason behind the proposition they're bringing into effect. So common good constitutionalists might disagree on how to deal with the ordinary run of cases. The important thing is they're not just stipulating in a circular fashion, we're just following the law, and they don't justify why that is a particularly attractive way to ascertain the meaning of the law. So we would a form of textualism could be justified, a form of intentionalism could be justified. There will be arguments, but they're both trying to justify the methods they're using by how it conduces to goods like stability, predictability, which conduce to the common good. And then the second thing they'd have in common is, while they may disagree on the first cut method, they would both agree in hard cases that there will inevitably be recourse to principles of political morality. And those, I mean, if you're a natural lawyer, you believe those just aren't arbitrary. They're not just make up whatever you want as part of the natural law.
Yeah, and I think that's why a lot of the reviewers of common good constitutionalism think that common good constitutionalism volume 2 needs to be an actual explication and defense of whatever the substance of the natural law is. Okay, we have I think 2 more minutes.
Sure, thanks so much. So at first glance, the common good constitution, it sounds utopian. It sounds that everything you want is in it. I mean, if you believe that family is good, family is in it. If you believe that federalism is good, then federalism is in it. And I know you said that it's underdetermined, like natural law is also underdeterminative. How do you know what's really good? And isn't it like we've seen with Bostock, where the liberals on the court will be happy to sign on to the most aggressively textualist opinion as long as they like the outcome, but then the next opinion they'll say, oh, well, we don't even need the text here. And my concern especially is that it seems there's always a religious, I mean, we heard about Thomas Aquinas a few times. It seems that there's I've spoken to a few living common good constitutionalists, And I asked them, how do you know what the common good is? And then they said, well, I'm a Catholic, so I know, and it's my religion. I don't know. Maybe the majority of people, common good constitutions are not Catholics. I don't know. But it always seems to come from, the throne of the Pope, which I think brings us back, and not just before the Reformation of Christianity, but also the founding fathers. They rejected the king after the people that came to America rejected the Pope, and also rejected the Church of England as a mixture of political and religious authority. So how do you know what the common good really is?
How do you know what is good? That's a nice, punchy question. No, thanks very much. So some critics of Adrian's book have said, you're hiding the ball. We all know you're a Catholic post-liberal. Why is there not more of that? The reason that the book doesn't discuss, and the reason that some of the essays don't discuss that in more fulsome detail, is that it's not a book about an ideal regime type, all things considered. It's an attempt to work out basic principles and precepts that should guide any form of political regime, religious or secular, because they comport with the natural law, and you do not need to adhere to any particular sectarian creed. As St. Paul said, those kind of principles are written in the hearts of man, and natural law would say
can be common good if we say that it reduces crime because there's less children born into poverty. We can get rid of undesirable genetic traits. That's common good.
Well, no. If you're a natural lawyer, then
many species kill their young that are unfit or abandon them.
Yeah, but that's Darwinism isn't natural. So the natural lawyer would say that the common good is not the means to get to the end. They're baked in. You can't, as my colleague Professor Michael Foran, University of Glasgow, says, you can't torture your way to the common good. In doing that, you will be acting intrinsically evil, and that is incompatible with any type of community that can say it's oriented to the common good. The common good itself requires respect for the rights that are due to people to allow them to flourish. That means respecting absolute precepts on intrinsic evils. It means respecting subsidiarity. It means respecting the integrity of the family unit. It's not the good of the state. The common good requires limits on government above and beyond positive law or morally relativist theories.
Thank you.
I think that's a good place to end it. Can you guys join me in thanking our panelists?